Hello and welcome all to Astrolegal, where we explore the fascinating intersection of space law. Today on Astrolegal, I am truly honored to welcome Professor Christopher Newman, a leading authority in space law and policy, and a professor of space law and innovation at Northumbria University. With decades of experience in academic as well as practical, Professor Newman has been at the forefront of global conversations of space governance, from the peaceful use of outer space and commercial exploration to sustainability, human space flight, and ethical challenges beyond Earth. His work bridges legal theory and real world policy, offering valuable insights to governments, international bodies, the media, and the students alike. Whether it's shaping the next generation of space lawyers or contributing to public understanding of space law, Professor Newman is helping define how we govern humanity's journey into the cosmos. It's a privilege to have him with us today for a deep dive into the future of space law. So, Professor, whenever you're ready, just let me know and we could start.
Yes, I'm ready to go. Thank you so much for having me on and for that very generous introduction as well.
You deserve it because you have been an amazing professor for me. Okay, so let's begin. So, given that most foundational space laws were established in the 1960s, what key changes or reforms do you believe are necessary to address the challenges of modern space activity?
So it's really interesting when we think about the evolution of space law, we tend to hark back to the treaties being founded in the 1960s and negotiated in the 1960s and 70s. And I don't necessarily think that's a problem because a lot of the treaties were technology proof. They were looking at behaviors, they were looking at the way in which states dealt with their responsibilities in outer space. There's not a lot that's, technologically focused in there because the drafters of the treaty knew they were looking at something that would happen, for years to come. So instead, what I tend to think of is rather than scrapping the old treaties and bringing in something new, we build and we develop on the work that we've already done. A lot of the outer space treaty is really valuable. The idea of no appropriation of outer space, the idea of states being able to authorize activities and always being accountable for their actors, whether they be governmental or non-governmental entities, the notion that we should avoid harmful contamination, the notion that states should be liable for damage caused by their space objects. Those are principles that I think still hold good. I think we can look at developing and I think we can look at increasing the range of laws and the range of understandings that we have about our space activity. But I think rather than looking back and trying to change it, let's look forward and let's see what the challenges are presenting, because I think there's a number of different challenges that we're seeing. We're seeing this real melting pot of commercial actors, of state actors, of military actors, of scientific actors, all coming together to work in outer space. So that's something we've got to think of. Is the model of having the state responsible for the actor still a one that is appropriate? I mean, it might well be. It might well be that works. But I think we shouldn't shy away from having the conversations. What I think we should do is build on the principles rather than, looking to scrap the principles and start again. Let's develop what we've got. Let's develop the shared understandings.
It's an amazing answer because when we expect someone to answer, they would just say that, oh, we need to just like scrap this and get something new because it's pretty old. But you had an amazing answer. Thank you so
It's
much.
it's something I genuinely feel. I think, we do need to develop and we need to look and constantly assess and say, is the international law doing what we need it to do? And my question would come back, well, fire it back to the community, fire it back to the people doing the activities. What do they want the law to do? Do they want a global police space force, hovering over, looking at different types of activity, restricting launch, restricting access to space if they don't play the way that they feel that other nations should? Do we want that, or do we want a more cooperative, understanding, partnership-based approach built on appreciating the unique nature of the space environment? And I very much think it's the latter.
I'll definitely ask my community about this question and wait for the answers. Moving forward, so with thousands of satellites and growing space debris, is space becoming a legal minefield? And who's accountable if some disaster strikes?
So, two very good questions there. Is space becoming a legal minefield? Again, if you don't mind, I'm going to challenge the premise of the question. Space has always been a legal minefield. There's always been issues of accountability and liability that have always popped up there. Right from the very first rocket going up, the issues of flyover were discussed and issues of who should be liable for damage caused. This is not, again, this is not new conversations. These are conversations that the space community have been having for decades now. I think what we're seeing is as the number of satellites in orbit increases, mathematics tells us that the chances of a collision increase and the chances of a collision causing damage, which is going to need some sort of legal intervention, increases. So I think the question of space becoming illegal, I think space has always been like that. I think it's the activity is always we're venturing into a new domain of activity, and that domain of activity has uncertainty regarding the contours of liability. And that then feeds to our second question: who's accountable if a disaster occurs? Well, again, the Outer Space Treaty kind of points us in the direction that states are internationally responsible for their national space activity, be it their own or be it that of their non-governmental entities, I think the treaty refers to. So we've got a state on the hook there. We've got a state that's responsible. We've got a state that's going to be liable if a state causes if a damage is caused by a space object of a launching state, then they are internationally liable. We know that from the Outer Space Treaty. We know that the Liability Convention tells us that liability can be broken down into two different areas. That is damage caused on the surface of the Earth or to aircraft in flight, and damage anywhere else, which is usually believed to be orbital damage and damage in outer space. So there's different liability regimes and different accountability regimes. The problem I think we have is the granular detail. Well, how does this play out in court? How does this play out when we get to litigation? What about arbitration? What about mediation? Questions such as that, such as would occur in any other terrestrial based dispute we haven't yet got to in space. And I think it's tempting to kind of look and be in a hurry to resolve this, but we haven't been doing space that long in terms of a species. We look to maritime. Humans have been going out in boats for thousands of years. Humans have been interacting and selling things for thousands of years. Yes, airlines are perhaps a more modern form of activity, but again, that's very well established, ubiquitous. It's relatively low cost compared to space. So I think we've got to be careful into rushing into a solution. We need to make sure that we get these principles right. We identify what the principles are. We identify what the venue is going to look like. We identify what the rules of evidence are going to look like. And crucially, I think, and this is something that I'm sure I'll come on to, we need to make sure that the evidence we've got is appropriate and actually probative of disaster and probative of fault, because I think that's one of the real areas at the minute that we don't have.
I guess that's one amazing answer because it's like instead of answering it in a normal way, you got some different aspects, and you also tried to answer that why there are no new developments in the laws as quickly as we want, and why is it being delayed? Because we want to analyze every aspect and then get a better one. Thank you so
Absolutely.
much. Moving forward, so I know you already answered this, but if you want to put in some more insights on this. So, do we need a more dynamic framework for establishing space law that can keep pace with rapidly emerging challenges? Or is it that the current approach is adequate?
I think we need an agile framework. I think we need agility in our legal systems, whether that comes from international law, whether it comes from national, whether it comes from softer mechanisms where disputes are resolved without the recourse to law. I think then that's going to develop and that's going to occur. But again, what I am going to go back and what I am going to talk about is the need for more data of space, data of the space environment. We're putting a lot of stuff up there, and I think one of the key questions is before we get to
So,
No
moving
problem.
forward, sorry.
Yeah, yeah.
As we prepare for long duration human missions, are legal systems adequately equipped to address the psychological and mental health risks that the astronauts may face?
Well, I think this is a really interesting, really good question because as we start to think about long duration missions, humans being away from Earth for a prolonged period of time, we really get to one of the significant weak spots of any mission. And that's humans. That's the actual human part of the system. Because humans, we all saw what it was like during lockdown. We all saw what it was like during the pandemic, being confined to a small area, not being able to go out, not being able to socialize with friends. We saw the profound effect it had on humans. And I think that's an interesting warning, an interesting lesson to keep in our heads that it's not going to be, it's not going to be like we see it in the movies. This is going to be a serious undertaking. The very type of people who we're going to need to populate colonies and populate communities on other planets are the very type of people who are going to hate being constricted and being restricted in their movements. So I think there's a lot to think about, not just in terms of the law, but in terms of the whole human experience that we're looking to do. Are we, how are we going to select these people? What type of training are they going to undergo? How's this going to work? Because